Aloha kako and welcome to the Kanaka Express. I'm Kale Gumapak, your host for this evening's show. And again, I'd like to thank you for welcoming us to your home. And I'd like to welcome my guest tonight, Dr. Keanu Sai. And most of you know who he is because he's been on most of my shows. And we're going to be talking about Hawaii's role and international law. And I think because we've been talking a lot about law and mortgages and what happens, war crimes and so forth, I think that tonight is a good time for us to talk about Hawaii's role in international law, and especially with Dr. Keanu Sai's background and with his PhD in international law, that this is a good time for us to really use his expertise and bring this in. So, Dr. Sai, again, welcome to the Kanaka Express. If you would, maybe you can explain to us what is Hawaii's role in international law.
Well, a lot of times we've been speaking on the show, we're always referring to Hawaii as a country, as a state, as an independent state. And we started to use terms associated with international law like war crimes, Geneva Convention, the laws of occupation. Hawaii has a very key role in international law, and it began in 1843 when Hawaii was recognized as an independent state on November 28, 1843. By Great Britain and France, followed up later by the United States, Secretary of State John C. Calhoun. Once that recognition of Hawaii as an independent state took place, you might say Hawaii was given birth to the scene of the international family. And the term independence, every country has an Independence Day. The United States has an Independence Day, which is when they were born into the international family, and that was July 4th. Hawaii's Independence Day, its birth, was November 28th. Now, when we speak of international law, a lot of people tend to confuse international law. And we've had this discussion a lot, where people began to use domestic laws interchangeably with international law, as if they're all law. Yeah? They're not. Okay, so there's a distinction between what is called laws of a nation, laws within a nation, called municipal law, or internal law, and laws outside of the nation, a law between nations, and that's called international law. So the word international, inter means between. National refers to the nations. So international law, by definition, is just laws between nations. Now, what is different at the international level than what you would normally have within the domestic level are what we call the sources, the source of law. So if I'm in the United States, the question I would ask, what is the source of laws of the United States? Well, it would be because the United States has a Congress. Laws passed by Congress are congressional laws or statutes. That's a source. So you got statutory law. You also have another type of law, a source of law, within the United States called case law, which is another word for common law. These are judge-made laws. So when a judge makes a decision, that decision, which was made by the highest court in America, called the U.S. Supreme Court, that has precedence, and it's binding on all lower courts. That is an example of a common law, that it has already been decided and it can be applied. So a lot of times when you see in court cases within the United States, they constantly cite cases that have already gone on appeal and have been adjudicated, like United States versus Belmont, United States versus Pink. These U.S. Supreme Court cases dealt with executive agreements, which is just like what Hawaii had or has between the United States that was negotiated between the Queen and the President. So those are laws within the country. Okay. Now, also within a country, you have an agency that can enforce that law. And that agency is a branch of government called the executive branch. And that executive branch is what executes the law. And within the United States, the president is the chief executive. And it is his duty to faithfully execute the laws passed by Congress. Okay? So when there is a dispute or infraction of the law, you have another agency or a branch within the United States government called the judiciary, the courts. They hear the interpretation of law, the violations of law, and then make decisions which could become common law, which is case law, together with statutory law. So that's what people are normally used to. You don't have that set up at the international level. You don't have a legislative body on the international level that creates laws. A lot of people think the United Nations is a legislative body. No, it's not. In fact, resolutions passed by the United Nations have no binding effect upon other countries, unless those countries specifically agree to that resolution. So a common misnomer is that the United Nations, the General Assembly, is the legislature. No, it's not. It's just an organization of states that address issues. That's all they do. They address issues. And when they pass resolutions, it shows consensus. It shows certain things that need to be done administratively and so on. Now, the sources of international law then, if there's no legislature, what are the sources of international law as opposed to the sources of law within the United States? So according to the International Court of Justice, there are basically three sources of international law. Okay? The first source, treaties. Treaties are agreements between the nations, which is international law. So it's a law between nations called agreement. So treaties, agreements, are the primary source of international law. And that clearly lays out obligations, duties, a breach, which is a violation, the basis for reparation or compensation, and so forth. So those are treaties. The other source of international law is what is called custom. Now, custom is what takes place between governments in this international arena. So as a government is negotiating with another government or in a relationship with the other government, their actions have profound ramifications, which is what we call diplomatic relations. Diplomatic relations creates a consistent behavior that is relied upon by either governments. So if one government states that we support you in this venture, and this other government says, thank you for supporting me, and I'm on this venture, that country who said they supported that venture cannot later say, we don't support it. If they created a consistency of a particular behavior that basically the other country utilizes as affirmation or agreeing to what I'm doing. What you're doing there is you're creating a custom that is really only unique between governments. And that's what international law is, customary. Now, then you have also general international law or general customary law. And that's when a particular action between countries, between their governments, are considered so foundational in relations that it becomes applicable to all the countries and their governments. And that particular custom of general international law is normally referred to, can be referred to as a norm or a peremptory norm. A peremptory norm is a basis, is a point of international law that is so fundamental that any breach of that would dismantle the entire system.
Can you give an example?
The equality of states. States meaning independent states. When a country is given birth into the international arena through recognition, they are now part of this family of nations. No matter how big or small they all are equal as far as sovereignty. So there is an equality of sovereignty. So countries on the international level, there is no hierarchy. It's equality. Now, there's a difference in strengths of governments, but not in equality. So you might say, an example would be, if we're in this room and we have 10 people, and one person is 5'2", another person is 6'5", another person is 400 pounds, another person is 160 pounds, they're all different. And they all have different strengths and different weaknesses. But they're all equal. They're all human. And there is an equality there that needs to be maintained. Okay? That's the same concept at the international level. So Liechtenstein, which is a very small country the size of Molokai, okay, has as much sovereignty and equality to Russia. But obviously, there are differences in size.
And maybe you can give an example of customs.
Now, a particular custom that is recognized as general is diplomatic immunity. Okay? So when an ambassador is in another country representing his government, it is understood as part of general international law that is uniform across the board with everyone, that ambassador has diplomatic immunity. So that's an example of a custom. You don't find that in a treaty. You find that in custom. And it's been used so consistently since 1648, which is the birth of this so-called family, that it has become accepted as general international law. So the countries themselves did not enter into an agreement that says there is diplomatic immunity. That's a custom. That's not a treaty. So that's an example of another source of international law other than treaty, custom.
Okay, good.
Now within the customs further, we get into the peremptory norm. I want to try to get back to that peremptory norm. There's a term that is also used that signals what is called a peremptory norm, and that's called jus cogens.
Well, when you say peremptory norm, what do you mean by that?
A peremptory norm, as opposed to a norm, which is a form of behavior that is accepted, a peremptory norm is a type of behavior that cannot be tolerated. Okay, a peremptory norm ensures that this particular norm cannot be violated. Okay, because if you violate it, it'll dismantle the entire fabric of international relations. And two examples of that, okay, where it cannot be violated, is the equality of states. So on the international level, states or independent states are all equal, okay, in legality, okay, but they're not equal politically. Others are stronger than some, okay. So the equality of states is the mainstay is the foundation of international relations. If the equality can be affected by a few states who are powerful, what stops other states from doing that against other states? So let's say two countries, Russia and the United States, enter into an agreement that will move to wipe out Liechtenstein's sovereignty illegally. What you're doing is you're violating the equality of Liechtenstein. And if you allow that to take place, what stops Japan and China from doing it to the United States? What you end up doing is you start to rattle the fabric of what maintains this very unique system called international relations and international law. Another rule or a peremptory norm that cannot be violated, okay, otherwise you will dismantle everything along with equality of states, would be the rule or the rules that protect the independence of states. Okay? So if Russia and Germany, okay, as an example, enter into an agreement called a treaty, which is international law, to illegally take out the independence of France, okay, they're going to gang up on them. That treaty, which is a law, cannot be considered valid if it's going to violate a peremptory norm, which is customary law, that protects the independence of France. Because if they allow treaty law to trump customary law, especially a norm, a peremptory norm that is a mainstay of this international relations, then what stops any country from doing that to each other? You got chaos.
I think an interesting example of that could be what's taking place with Syria and the U.S. and Russia.
It's a good point. Yeah. Now, what was happening with Syria, though, had nothing to do with the sovereignty of Syria
Right.
and its equality. It had everything to do with the government. Yeah. And that government violated a particular norm, which is you're not supposed to use chemical weapons.
Right, right.
That's
right,
a norm,
Right.
which also was put in a treaty that bars countries from using chemical weapons. So what you see there is that's a good example, is a play on treaties, custom, norms, and governments. And you notice how they're playing this. The U.S. cannot just go in on their own.
That's right.
They thought they could, and they could try to justify it because they said, well, they violated a treaty, which is an international law. You can't use chemical weapons. But how do you address that in another way? And that's when Russia introduced the resolution to say, let's move to get all the weaponry out of the hands of that particular government. But they couldn't do that without the agreement of the Syrian government.
Yeah.
Right? So
Yeah, okay.
President Assad had to agree. That's the basis of sovereignty. They're equal. But yet here's a display of one is more powerful than another. Yeah, that's a good one. Yeah.
Okay.
So that's a good example of how it plays out.
Yeah, yeah. Okay, now bringing it back to Hawaii, you have, been involved, in, getting your doctorate's degree, your master's degree and so forth, and with the acting Hawaiian Kingdom government and your position as acting regent. Can you explain that?
Sure.
And how that all works with this?
Okay. Well, remember the norm that I said that is a part of the international law, which is a peremptory norm, a customary law, not a treaty, but a customary law, that overrides any treaty, would be the rule or the rules protecting the independence or sovereignty of countries, okay, against aggression, okay, and also the rule that maintains the equality of sovereignty, of countries. What happened in 1898, Hawaii was occupied. The United States took us over, and we covered that in the past shows, okay? But by taking over Hawaii physically, they didn't acquire the sovereignty, because under international law, you have to acquire it from the Hawaiian Kingdom. You just can't claim it. So the United States could no more claim the sovereignty of Hawaii, which was already a country, then the United States today can claim the sovereignty of Syria. Okay? You still have Syria there, which is the government. They got to agree to something. That never happened here.
Yeah.
So when Hawaii was occupied, international law came into play. But what hid that from the international community and the local community was indoctrination, Americanization that started since 1898 in getting people to believe, and this is what we shared early on a show, that public schools were used to indoctrinate the children in the early 1900s as far as believing they're American, as far as speaking English. And that process of Americanization, which is indoctrination, institutionalized, effectively erased the memory of the Hawaiian Kingdom for much of the population. Yeah. Now, that process there is power. That process there is political. That's not legal. The Hawaiian Kingdom, the country, still exists. So to put it in another way, when you talk about international relations, it's like talking about a freeway. And the only cars that can get on there are countries, okay? Because countries are cars. And if you are recognized, hey, you got a Porsche, you just made that in your backyard, and you get it recognized by the rest of those cars, you get to drive on the freeway. Hawaii was driving on that freeway since 1843, okay? And it was in the fast lane as well. And it could move to the slow lane, but it was on the road. Since 1898, that Porsche was prevented from being allowed to get back onto the freeway. Because in order to get back on the freeway, okay, this Porsche, which is a country, you need a driver. That driver was taken out under force. The Queen. Yeah. The executive agreements we talked about. So the Queen, as a driver of this Porsche, this Hawaiian Porsche, was removed. So this Porsche has been in our backyard all these years, overgrown
With no
weeds.
driver.
Well, nobody even knew what it was because it just looked like it was so thick of kiawe until somebody said, wait a minute, there's something blue in there. And you might say that's what we did. We began to realize that this Porsche, called the Hawaiian Kingdom, was right in our backyard. And in 1990, in the mid-90s, myself and a few other people began to inquire and look into this, and we realized by cutting down all the kiawe trees and all the weeds that covered this car, to our surprise, the car was already made. But the car hasn't been on any road for over 100 years because there's no driver. So what we basically did was we utilized what is called the doctrine of necessity. Okay? We're going to take this car back on the road. So we created what is called an acting government. And an acting government is not international law. An acting government was established under Hawaiian Kingdom law that applied to that particular Porsche. And we only could do that by understanding how that Porsche operated. And that's how we created what is called the acting government. So the acting government cannot say it represents everybody. That's why it's called acting. The acting government, by necessity, is merely the temporary driver of this Porsche, which is about to be taken onto the, to re-enter this highway of international relations with other cars that are driving on it. And that's what we did. So when we created the acting government, it is temporary and it is limited. It doesn't have the power to enforce. There's no effectiveness that it would have in Hawaii because we're occupied. And that's one of the exceptions to the rule of effectiveness, because governments cannot just be on paper. Governments have to be effective. They got to be able to do something. And it has to be effective within the country they're in, but also outside of the country, international relations, through diplomats, treaties. The exception to the rule of effectiveness within Hawaii, okay, the exception to the rule would be occupation. You can't be effective if you're occupied. That's the point. That's why it's like you're kidnapped. So that is an exception to the rule of effectiveness, but it is not an exception for the government, whether acting or not, to have effectiveness on the international level. That's another criteria, that it can't just be on paper. You're driving. You got to drive this car on the international level. So what we did was we had an opportunity to drive the car to the Permanent Court of Arbitration in the Netherlands. And what this case was about in the World Court was a case that was dealing with an individual named Larson from the Big Island, Kea'au. And he followed Hawaiian Kingdom law. He was arrested by the police in Hilo and went on trial, and he was put in jail 30 days, 7 days solitary confinement, because he was following Hawaiian Kingdom law, because he was standing on these laws. Now, when I'm saying what I'm saying is his attorney was representing him in making these arguments. Miss Ninia Parks is the attorney. And she was making these arguments in court saying her client is following Hawaiian law, not U.S. law. Because if he follows U.S. law, he'll be committing treason. Because Hawaii is not part of the United States unless they can provide a treaty that Hawaii is a part of the United States. So after he was incarcerated, his attorney basically filed a lawsuit against the acting government and accused the acting government for liability for not protecting her client. Because if you're the acting government, you're responsible for the protection. But remember, we're not effective in an occupied country, but yet we're still responsible because we're the government. Well, we're not responsible, we're actually liable. So we said we're responsible, but we are responsible, but we're not liable. The United States is liable. But if you want to take us to court, we need to sign an arbitration agreement so we can go to the Permanent Court of Arbitration in the Netherlands, in The Hague. That court deals with international matters. So this was the first instance that Hawaii, the Hawaiian Kingdom, was able to take the Porsche back onto the highway of international relations and actually enter an international court. And you can't enter that court unless you're a country. So why don't we go ahead and show the video, of the proceedings that went up.
Okay.
It's a 20-minute video.
20.
Yeah.
Okay, Dane, if you would.
Sometimes you get too close to the tree, you lose sight of the forest. And the forest is the nation. And that's what we always have to look at. How is this nation born? How does it continue to exist? And I think that's the discipline. That's where we have to stay on that path. This is a culmination of all of that research, all of those efforts. I'm talking about a lot of pain, talking about a lot of joy. You know, this is the history of our people for the last 150 years.
Please be seated. The Tribunal invited Mr. Hans Jonkman to sit with us at the end of the table. He was the former Secretary General of the Permanent Court of Arbitration for many years and had a great deal to do with the revival of the Permanent Court as an institution, and it's a great pleasure to see him.
And the writing of the new rules.
The Tribunal today will hear submissions on behalf of the claimant by Ms. Parks, and tomorrow we'll then hear the response of the defendant. So on that basis, I'll call on Ms. Parks.
Lance Larson filed this case as a subject of the Hawaiian Kingdom, taking it for granted that his rights as a Hawaiian national are intact, and that his country, while occupied, the sovereignty remains intact. At all times during the pleadings, he has been operating, assuming that as a matter of fact and law, he is a Hawaiian national. The respondent in this case, the acting government of the Hawaiian Kingdom, has also at all times maintained as a matter of fact that the Hawaiian Kingdom is a sovereign nation, albeit an occupied sovereign nation.
As I stated before, we are the respondents, and that we're basically defending ourselves, that we have done everything that we were capable of doing within the framework of occupation to protect the rights of Mr. Larson. But through this process, we're also going to be understanding the relationship that a government has with its national within the framework of occupation. In that regard, we're very thankful for this case to go forward.
We've taken Lance's case to the international level. Lance has been making arguments in state court, and we did go to federal court. And unfortunately, the denial of his nationality was so extreme within the state of Hawaii judicial system that we decided we wanted to go to the international level so that people outside of Hawaii could see what Hawaiian nationals are going through. And the testimony and the written pleadings and the oral testimony that Lance gave is now on the international record. Transcripts, irrespective of what the judges rule, we have now put that as historic evidence on the international level, and I think that was our main goal. Of course, we would like these judges to give us some indication of what Lance's rights are with respect to the government, or what steps would be appropriate to take next.
There's no such thing as liability in the air any more than there's such a thing as negligence in the air. So you have to say in what respect there's been a breach.
I very easily could reformulate the issues in a duty, breach, causation, more of a tort type analysis. The way the international pleadings were set forth did not seem to lend to that. But the specific actions mentioned in the documents in terms of the consistent denial of his nationality, that is the breach.
What people may overlook is that Lance Larson's rights, and we have conceded that, were violated. He was thrown in jail. He was incarcerated, and 7 of those 30 days, he was in solitary confinement. That's a real issue for Lance Larson. People may speak about it lightly, but that wasn't them in that jail. And all he was doing was following his law, a law which he can defend.
The Hawaiian Kingdom case is a very unique case, and the law tends to be set up for what is the usual case. So when you come in with an unusual case, you're going to have a couple of hurdles you've got to overcome. And the important thing is to find out what's bothering the decision maker. So as soon as we found out what was bothering them, we moved our tanks over to that front. And then, as you know, when I got up, I decided I was going to get to them before they got to me. You don't have to say that the United States is illegally occupying Hawaii. You can say there is some argument that can be made that the United States is illegally occupying Hawaii. Under that condition, what is the responsibility of the Hawaiian government and the Hawaiian Kingdom to its nationals who are claiming that they have a right to be ruled by their government's laws? On the other hand, you could go further and you could say, well, we're going to, as a arbitration panel, we're going to look at the legalities of the United States presence in the Hawaiian Islands. You could look at that issue and decide, well, without the United States' participation, we really don't have enough evidence and information to make that decision. But in deciding this particular arbitration, an arbitration panel could well decide that based upon the information we have, which we feel is satisfactory, that we believe as a matter of international law, it appears to us that this occupation is illegal.
In this document, the United States Department of Justice, which the first page acknowledges that this comes from the United States Department of Justice, acknowledges that a joint resolution alone is insufficient to acquire another nation. Other exhibits in the memorial show that both the sovereign of the Hawaiian Kingdom, Queen Liliuokalani, and many of her subjects, through the petition against annexation, were not only deprived of a right to vote and acquiesce into becoming a part of the United States. In fact, they adamantly protested on the record and sent those protests to the United States State Department, saying that they did not want to become part of the United States.
I'm pretty confident that what we've done to date, lives up to the dignity of our ancestors, which is what's pushing us to do everything that we're doing right now.
It's not talking about culture, it's not talking about all these other things. It's, if we're going to present Hawaii's existence, its continued existence, and prove to the world that our sovereignty was never diminished, we needed a cornerstone. The Queen laid that for us.
It's because of the work that Queen Liliuokalani did that provided the basis for us, because if she hadn't done what she did, then we wouldn't be able to make the arguments that we're making. In fact, this arbitration is really an extension of the careful way in which she preserved the status of the Hawaiian Kingdom.
The second day we were here, we had a meeting with Phyllis. So Umi, myself, and Keanu, we went to go meet Phyllis, and she comes to the door, and you know how imposing that place is. It's just, You go, oh God, it's here, we're here, oh my goodness. But she comes up this step and she had her assistant with us and she turns to him and says, Dane, this is the Hawaiian Kingdom.
The dominion of the Hawaiian Kingdom. In summary, from 1840, the Hawaiian Kingdom possessed a constitutional government with elected and appointed officials and a complete system of civil and criminal laws to govern Hawaiian territory. On April 8, 1842, King Kamehameha III and Privy Council commissions 3 envoys to secure international recognition of Hawaiian independence. And these individuals are Timoteo Ha'alilio, William Richards, and Sir George Simpson. On December 19, 1842, Hawaiian envoys secured United States President Tyler's recognition of Hawaiian independence. November 28, 1843, the British government and the French government formally enter into a declaration recognizing Hawaiian independence. In our pleadings, we refer to that as the 1843 Anglo-Franco Proclamation. From that point, Hawaii has had its statehood recognized as being independent. As such, it began to enter into these treaties. Austria-Hungary, Denmark, France, Germany, Great Britain, Italy, Japan, Netherlands, Russia, Spain, and the United States of America. International recognition is evidence that the Hawaiian Kingdom have diplomatic representatives as of 1893 from those countries, as far as consulates and embassies.
The important part of this case is to have an authoritative determination by competent people in the international field as to the status of the Hawaiian Kingdom, because that is going to clarify for a lot of people the foundation for thought in the future. Our view is that has not been clearly understood.
What we've had to do is to take a very unusual historic situation and try to mold our situation into your procedures. Frankly, I think it was quite a challenge, but I really do believe that we have done that. You'll see on the first page that we've identified the claim that's been made, that through the inaction of the Hawaiian Kingdom, Lance Larson has experienced his problems. The reality of it is that the United States government itself has recognized the fact that the overthrow of the Hawaiian Kingdom government was unlawful. The United States itself has recognized that the sovereignty of the Hawaiian Kingdom, in fact, was never terminated.
Could you just read what the Solicitor General said verbatim again?
So this is only a part of it, but it says between 1826 and 1893, the United States recognized the kingdom as a sovereign nation and signed several treaties with it. The United States has concluded that it bears a responsibility for the destruction of their government and the unconsented and uncompensated taking of their lands.
Right. And that's a verbatim quotation from the Solicitor General.
That's correct.
In argument. It doesn't actually say that the Hawaiian Kingdom continues to exist, does it?
No.
It says that the United States has a
It
responsibility.
doesn't say that. Actually, in the joint resolution, there's more of the substance of that. But what is important is that the sovereignty of the Hawaiian people is now being recognized by the government of the United States, which there has recently been before Congress is a bill to recognize the sovereign status of the Hawaiian people.
Is the concept of sovereignty, which you address, that of sovereignty over Hawaiian nationals, or is it a geographical sovereignty, namely sovereignty over the entire Hawaiian Islands, including all those who are resident there, whether they be Hawaiian nationals or, for the moment, regarding themselves as not Hawaiian nationals but nationals of the United States?
For most people, it means you have to provide for citizenship of the people who are there if they wish it. But the international community has amazing versatility in figuring out the answer to complex problems. That would be another stage along the process. We're here because the Hawaiian government, the Hawaiian kingdom, and the Hawaiian nationals need a better understanding of their position, the position of the Hawaiian kingdom in international law, given the complexity of the present situation.
The point is that even if it was the case that the UNCITRAL rules, I mean, there's a textual problem with the UNCITRAL rules, which we pointed out, but even if it was the case that the UNCITRAL rules on the face of them require that the dispute be characterised as commercial, that's a matter between the parties, and the basic principle of the UNCITRAL rules is party autonomy. So as between yourselves, you can waive that requirement without any difficulty. The problem, it's more difficult to waive a requirement of the consent of a third state if there is such a requirement.
That's the issue. I mean, that's the entire issue. Can we proceed in the absence of the United States?
And Mr. Dubin, that's the issue, whether you go under one set of rules or the other.
Exactly.
Yeah.
Rather, what we find is that the United States has never expressed itself as an occupier. Who would? They will never admit to occupation. But yet, to admit to occupation is, in a sense, to admit to the continued existence of the Hawaiian Kingdom as an independent state, which is really the crux of the matter.
Which is actually what is holding up, you might say, this issue to be resolved.
Thus, the legal order, thus, the reestablishment of the government, thus, the relationship between its nationals.
I mean, to be slightly unkind, but thus the issue in rem. The point is that if the Hawaiian Kingdom continues to exist, its existence is in rem. It's not in personam. The Hawaiian existence, the Hawaiian Kingdom doesn't exist solely in the opinion of Mr. Larson.
Right. But that existence should not be dependent upon an occupier, because you basically put the occupier on an equal footing with the Hawaiian Kingdom in its own territory. So really what needs to be addressed is what came before the occupation, whether the statehood or whether the legality or illegality of the Hawaiian Kingdom, not the illegality or legality of the United States as an occupier. Should the tribunal find it has jurisdiction, we are prepared to submit an offer of proof.
We felt that this tribunal would offer some clarity so that for the first time we have a third party to present these type of merits that can be scrutinized by international law, rather than taking it before a United States tribunal, which could not rule on it to the detriment of itself.
So in that sense, there is really no other way to address this issue. And the opportunity did arise because it was Mr. Larson who was adhering to Hawaiian Kingdom law. And if the United States was adhering to occupation, not whether they're illegal or illegal, but if they were adhering to the laws of occupation, we wouldn't be here right now. If the tribunal feels, and I strongly submit, that they can address the issue of Hawaiian statehood without the United States, because you are looking at Hawaiian statehood before the occupation, whether the occupation was legal or illegal, and whether international law safeguards the continuity of a state during occupation.
Certainly to advocate the rights of the Hawaiian Kingdom is kind of historic, and as you do it, you sort of feel like the Queen is with you there in the chambers. So there's a lot of emotion and a lot of feeling of historic significance.
Just the fact that we are in the Permanent Court of Arbitration, in the Peace Palace, in The Hague, and our country's history is on record now, forever, in perpetuity. Anybody can pull this up anytime after this, on the websites, through the libraries. We have realized our goal.
Well, it was like watching a video that was just taped yesterday, but this video was shot 13 years ago, and the information is very consistent in what we're saying today. And nothing. It seems like nothing has changed except that it still remains consistent. There were a couple of things that were mentioned in the video that I'd like to kind of get clarification from you. And one of the arbitrators mentioned in rem.
Okay.
Can you explain to me what did he mean by that?
Well, if you notice what he said before, he said the in rem matter. He said to be slightly unkind.
Yeah. Yeah. He was, I think he was trying to apologize or something when he said that.
Yeah. The reason why he said, let me provide you the context for that. What was happening here was when he mentioned that was on the third day of the hearing. That was the third day of hearings. Okay. Ms. Parks went on the first day. That was on a Thursday. I went on a Friday, so you notice I had a blue suit. Okay, and Gary there. That was on a Friday. And then Monday was the final day. So Ms. Parks would have some time, and then we have some time. Well, throughout that process, Ms. Parks kept saying that the Hawaiian Kingdom exists. It exists. The Hawaiian Kingdom, and she kept saying it. So Professor Crawford, who is the president of the tribunal, who's from Oxford, okay, or actually from Cambridge, okay, he said to be slightly unkind, he says, thus the issue in rem. The term in rem is a Latin term that says it applies to everyone. Yeah? So he says, thus the issue in rem. He said that the Hawaiian Kingdom exists, its existence is in rem. It applies to everybody. It doesn't only exist in the opinion of Mr. Larson, which is in personam, another term he used. And then he says it exists. So he's basically saying we know that the Hawaiian Kingdom affects everything. So you don't have to keep telling us the Hawaiian Kingdom exists because you're in the court. We're moving to address the indispensable third party rule on whether or not Mr. Larson, through legal counsel, can continue to attempt to sue the acting government without the United States as a participant. That's what they were saying. So that's the gist of that statement, which I find really interesting in how he chose that word in rem. Yeah. So if you notice also what I'm doing in the proceeding was this was on a third day. What I'm getting to is we knew, the legal team knew, Larson would not be successful in his argument that he's going to sue the acting government for not protecting him. Okay, we knew that. He needed the United States as a party, okay, because we're the defendants in this case. So you might say for our time on Friday, we decided to help Ms. Parks sue us. So we're going to try to argue that you can't sue us without the United States. What that did was it gave us the opportunity to present Hawaii's history, to present the PowerPoint, to present the arguments. Because rightfully, we didn't have to say anything. Because remember, we're the defendants in this case. Now, on the last day, we knew there is no way that Larson, through his counsel, his attorney, can go beyond that rule, that indispensable third-party rule. We knew that. So you may notice at the last part of the video, where I'm wearing the brown suit now, which shows it's a different day, that what I wanted from the court, the arbitral tribunal, was to determine not whether or not the United States is illegal, but what was the Hawaiian Kingdom. I wanted the verification of Hawaii as an independent state. That's what I was pushing. What was the statehood of the Hawaiian Kingdom, not the United States. So I did it on my own. And we're the defendants, and I'm asking for that. What ended up happening was we ended up getting what we wanted in the arbitration award. That the arbitrators actually put it in the award that said in the 19th century, the Hawaiian Kingdom existed as an independent state, recognized as such by Great Britain, the United States, and various other states. That's what I needed. It was implied we are a state, because that's how we got into the court, it is now explicit that in the 19th century, that statement, what that statement means, our Porsche was on the highway in the 19th century. That's what I needed. Because then you have peremptory norms, yeah, that we spoke about earlier,
Yeah.
in customary law, in general international law, that maintains that independence. And you notice I even stated that in the video, that international law safeguards the independence of a country during occupation. That's one of the rules. Yeah. But I needed a foundation. I needed a point of reference. Our history has it. Our treaties have it. I needed an international body of a high rank to verify that. Not recognize our sovereignty, verify Hawaii was an independent state. If it was an independent state, it continues to be an independent state. So that was very important. Now what's interesting is on the last day, we're coming out of this is the last day of the hearing. It's all finished. And we're walking out. And what's interesting, two of the arbitrators, Professor Crawford and it was Professor Greenwood. Now, Professor Greenwood, he's now a judge on the International Court of Justice. He was elected by the United Nations General Assembly. He's been sitting as a judge at the International Court of Justice since 2009. In the year 2000, right after our hearing, on the last day, as my legal team and I are walking out, after we gathered everything, because the arbitration oral phase was completed, we're walking out, and as we're walking out, we're walking into a hallway, okay? And up above us, behind us, was the arbitrator's room. So as we're walking out, the two arbitrators, Professor Greenwood and Professor Crawford, are walking, and we eventually meet. We came to meet. And Professor Greenwood came up to me, specifically came up to me, and he put down his briefcase and he extended his hand to shake my hand. And I thought, oh, okay, you just shake. Okay, well, thank you, sir. Have a good day. And thank you for serving as an arbitrator. Because Greenwood was the one that the acting government selected as the arbitrator. Because in arbitration, the parties select their arbitrator, and then these two arbitrators selected the president, which is Crawford. So Lance Larson's attorney selected Gavin Griffith from Australia. He's a Solicitor General. We selected Professor Crawford. And then Professor Crawford selected, together with Gavin Griffith, the president. And that's Professor Crawford. Okay. So Professor Greenwood extends his hand to me, and he shakes my hand. And he says, "It is truly astonishing that you are not an international lawyer." He said, "You were the only one in these proceedings who gave the most succinct legal arguments in this case." So I was like, kind of taken aback. Thank you. And I said, well, I have common sense. I'm a retired captain from the, Field Artillery, National Guard. And I just followed the procedures. And he tells me, don't lose your common sense as you move down this road. And that was our parting words. And I haven't seen Professor Greenwood since that time. And then I found out in 2009, he was elected by the General Assembly. He's now a judge on the International Court of Justice, which exists right across the hall in the Peace Palace, which is where the Permanent Court of Arbitration is housed. Yeah, so that was quite interesting.
Wow. Wow, incredible. Now, since that appearance in the World Court of Arbitration, that was, I guess, the icebreaker for you, that took you to other places that was necessary. And maybe you can take us and tell us why.
Okay. Now, clearly what the arbitration provided was the means by which we could use, and we did successfully, in verifying that the Hawaiian Kingdom continues to exist as a country. So you might say our Porsche that has always been here since 1843, but for the last 100 so years, it was in the brush and not on the road.
Yeah, you started putting on some polish a little bit on the Porsche, huh?
Well, not only polish.
Put some gas.
Put gas, and we drove it. So we drove it. We drove the Porsche to the Netherlands. Yeah, figuratively, we drove it to the Netherlands. Now, how does a Porsche get to the Netherlands? Cars can't drive on their own, right? Countries can't drive on their own. They need governments. Governments are the drivers. And drivers in these cars, called countries, can be replaced. Drivers change as governments change, but the car is still the same. Okay? So what we needed to do was drive the car. And by us being able to go to the World Court to have the case heard, we did something not only to verify Hawaii's existence as a country. What we did was we began the process by which the government itself, the acting government, a temporary government, just temporary, is the bona fide driver. Because how did the Hawaiian Kingdom get into the arbitration? You needed a driver, and that was us. But what we did, though, was because there was so much confusion out there, so much misunderstanding, we never wanted the focus to be on the drivers, on the driver. Yeah? We wanted the focus to be on the Porsche, because that was something new. And nobody can deny that Porsche is moving. Yeah? So you might say we made a decision that worked in our favor. We turned the car around on the highway, and we learned how to drive backwards. Okay? So as a driver, which is a tinted window in the back, they can't see who's driving, but they can't deny there's a Porsche moving on the highway. So you might say we're using a monitor. Yeah, you know when you put the car in reverse and there's a monitor that shows the back. We're driving using the monitor, and we're driving 5 miles an hour. What we needed was to take away the focus from the acting government, keep the focus on the car, but at the same time, what we are going to naturally acquire through 13 years of driving this car backwards is the recognition by the other cars on the road that we're the driver. And that is called a customary prescriptive right. Okay? A customary prescriptive right under international law to represent the Hawaiian state, which is the Porsche. We could only get that through time because of this extraordinary situation we're in, of prolonged occupation, indoctrination, you name the ills, we got them. And there is a rule in customary international law that if a driver of another car knows that you're driving and they're not protesting against you, that failure to protest under customary law is actually an acquiescence or an agreement, an acknowledgement and recognizing that other driver driving. Now, that type of a process is called prescription or lapse of time, where you acquire a right through consistent behavior of others in relation to, let's say, the acting government's actions. The first step on that was not only, it dealt with the Permanent Court of Arbitration. Not only did the Permanent Court of Arbitration verify the existence of the Porsche, it provided an opportunity for one of the drivers of the United States, for the driver of the United States, its government, to actually recognize the acting government. And this is what happened. In, let's say, in February of the year 2000, the hearings that was there was December 2000. In February of 2000, I called the Permanent Court of Arbitration because I was the representative of the acting government, of the legal team. I was the lead agent. What happened was, I called the court for procedural matters. And basically what I found out from them, after them giving the information, is they said, Mr. Sai, could you please stay on the phone? The Secretary General would like to speak to you. And that Secretary General's name is Van den Hout. He's a Dutch national. So according to the 1899 Hague Convention, the Dutch run the Permanent Court of Arbitration. It's multinational. So what the so Secretary General Van den Hout comes on the line, and he provided this suggestion to me. He says, Mr. Sai, in order to maintain, now this is his choice of words, because at the international level, you have to be careful what you say, because it could be used against you. Yeah, that's called custom. He said, in order to maintain the integrity of this case, he highly suggests that I travel to Washington, D.C. on behalf of the acting government and provide a formal invitation to the United States State Department to join in the arbitration. What he wanted me to do was to ensure that the United States had full knowledge of what was going on. And that if they felt that they had sovereignty over Hawaii, they could basically move to tell the court to back off and stop the case. But they have to prove it. They got to show evidence that they have Hawaii, they have the sovereignty of Hawaii. If they don't do anything, they acquiesce to the recognition of the Porsche in the court. And it's not theirs. And that's not their driver driving the Porsche. So when I traveled to Washington, D.C., this was on March 3rd, at a meeting with a representative from the State Department, who I delivered information to, all the records of the case up to that point, and who do I speak to address this? The next day, I was on a conference call with John Crook from the United Nations Affairs Department, legal section. John Crook, Mr. Crook, couldn't believe the case was actually taking place. And I told him the Secretary General sanctioned this and authorized it and actually recommended this invitation that we give. In that meeting, I fully disclosed the Porsche, the driver, the person claiming to be injured by the Porsche, Lance Larson, the Hawaiian Kingdom, the acting government. And that the issue here is whether or not Lance Larson's rights were violated, which were violated by the United States, not by the acting government, but he was trying to hold the acting government accountable. Full disclosure. He watched his P's and Q's. After that meeting, I reduced everything to writing. I sent him a copy of that letter that documented the meeting, and I CC'd it or carbon copied it to the Permanent Court of Arbitration while I was still in Washington, D.C. They got it. 2 weeks later, we get notified by the Deputy Secretary General of the court, Ms. Phyllis Hamilton. And she says that the American Embassy notified the court that they have no intention of stopping the case. By not stopping the case, they are recognizing the situation. Okay? That's profound in customary law. It's not a treaty, it's customary law. Then she said that the United States specifically requests permission from the acting government to have access to the public records, the transcripts, and the pleadings. So now you have the driver of the United States car asking the driver of the Porsche, can they have access to the case? Make it public. And we said, absolutely. Now, that is profound there because what you have is direct acknowledgement, not a protest. Then after the case in December, after the hearing, the last day of the hearing in December, we're notified that the Rwandan government wanted to meet us, and we caught the train from the Netherlands, from The Hague, down to Brussels, Belgium, to meet with the ambassador of Rwanda, who told us in this meeting that the Rwandan government is prepared to report to the United Nations the prolonged occupation of Hawaii, the prolonged occupation of the Porsche. That was a direct acknowledgement of the acting government, the driver, and the Porsche, and asking us there already, would we agree? Well, we said we couldn't because we need to go back home and begin re-education. And that's when I entered the University of Hawaii in January of 2001. This was December of 2000. So what we have there are two instances that are going to work in our favor because it's building a momentum. It's a consistent behavior amongst certain governments of recognizing the acting government, de facto recognition. And then in 2001, we're able to file a complaint with the United Nations Security Council headed by China. And we were able to file that under the United Nations Charter, Article 33, which says a state that is not a member of the United Nations can file a dispute with the Security Council. Well, here we took this Porsche to New York and delivered a complaint under that provision, and it was accepted. What's important is not only the acceptance by China of the complaint 1 year after the arbitration, but the United States did not protest they didn't protest that complaint. What's happening here is you're starting to see a consistent behavior that's building up into creating the right of the acting government to temporarily represent the Hawaiian state in international relations. It's being effective. Then when I went back to concentrate back in school to get my master's degree and my PhD.
Now, before you move on, there's some question as to why did you not, with the Security Council at that time, just pursue it further?
One thing what was put in the complaint. Now remember, we're driving backwards.
Right, right.
Okay, we're going slow.
Right.
We're not driving fast. We're driving really slow.
Okay.
So the normal trip it takes to get there on jet, we're using a single prop. You have to be careful playing this game, because once the United States enters a protest or starts to challenge the acting government, yeah, we cannot use their actions to our advantage. They're not denying the existence of the Hawaiian Kingdom. No, the court already verified. The Porsche exists. What we could do is, unbeknownst to ourselves, we could actually set up a situation where they're going to negate the driver of this car. So we have to be careful. Okay, so we're driving slow, making sure the focus is on the car, not on the acting government. Because we can't say we represent everybody. And that's why we're acting, you know. But we can't represent everybody because you can't do that during occupations anyway, because you don't have elections during occupations. Government and everything is suspended. So in that complaint to the Security Council, all we asked as far as a relief, requests for recommendations on what needs to take place. Very open-ended. The reason is, it was not intended to initiate any proceedings because we knew the United States was on the council. What we wanted to see was, can we get into the door and get it accepted? That's what we wanted. Can they accept this as a state, not a member of the United Nations? Whether or not they proceed with proceedings, too premature at this stage. We're still feeling things out at the international level. And it's not like we have anybody in Hawaii who is fluent in international law. No, trust me, we don't. That's why I went to UH, to become fluent in international law with a PhD. So I can speak now with not only experience, but now with some expertise. Yeah. I couldn't do that back then.
Okay.
We're still driving the car backwards on this highway. So by focusing on education and getting my master's degree and the PhD and coming up with a solution on how to fix the problem, not leaving it up to somebody else or another country to fix this problem. No, we're going to be in control of this. That was what my PhD was all about. What ended up happening was, from 2001 to my PhD, that's 7 years. We added 7 years, okay, to the 1 year since 2000, 8 years of silence, okay, silence. Then we're going to move ultimately to the United Nations General Assembly. We have to get into the General Assembly because there is the same provision exists in the charter that says a state not a member of the UN can file a complaint or dispute with the General Assembly, just as we did with the Security Council. The reason why I want to get to the General Assembly, because you have 193 countries there. And we had 46 treaty partners in the kingdom. So by virtue of successorship, countries that got their independence, like let's say Vietnam from France. Well, that means the French treaty that Hawaii has with France would also apply to Vietnam. So we have not only 46 treaty partners, we have successors to include 173. There's only 193 members of the UN. So what we're going to do is, we're now going to take this Porsche in 2012, August, drive it up to New York, and deliver another protest. Now, this is a protest and demand, saying all of these countries are in violation of the treaties, and that we demand that you comply with international law. And, more important, not just treaty violations, but the peremptory norm. Remember that peremptory norm?
Right.
That peremptory norm, which is what protects the rules that preserve the independence of countries, of states, and also the rule that maintains the equality of states. And because we've been violated, and it's clear, we need you to comply. And it was accepted by the president of Qatar, president of the General Assembly, who was an ambassador of Qatar in August. And it went through their legal department, and it verified that the protest met the procedure requirements under the charter. So what we have there is another instance of exercising the right of the Hawaiian Kingdom and bringing it to the attention of more countries. Now, what's important is a year has passed. This is September of 2013. The protest was filed in August of
In
2012.
August, correct.
No country, including the United States, protested. None of them said, this is frivolous. None of them said, this is not the acting government. Silence. Remember that custom? Silence also means acquiescence. It's called acceptance. So they basically, through a year, by not complying and by them not protesting, they've agreed of the allegation that they're in violation of treaties and peremptory norms. Now, where do we go from there?
Yeah. What happens now, since they never protested? What's their liability, if any?
It's now compliance, strictly compliance. We've got, in the past 13 years, in this way of driving backwards, we got 173 other cars acknowledging the Porsche. They've acknowledged it. And now that can be used for the last 13 years against them. They can't say they didn't know. So we've developed a right for the acting government to represent the Hawaiian state to now be in a position to move upon compliance. And the arm that will issue an order of compliance that can affect all members of the United Nations, okay, irrespective of whether or not they had a treaty with the Hawaiian Kingdom, but all members of the United Nations, they can effectively have the International Court of Justice issue an order. We can actually get them to issue an order to have all members of the United Nations to no longer recognize the illegality or the presence of the United States as if it's legal.
Wow.
Because if they don't do that, they are now maintaining a serious violation of a peremptory norm, which is the maintenance of equality and the rules preserving independence of states.
So who would enforce this?
Well, governments enforce it themselves. See, and that's the thing on international law. But the International Court of Justice can only hear cases of states, only states. Okay? So once the International Court of Justice gets involved, which is going to happen soon, because we're going to drive the Porsche to The Hague again. And we're not going to be driving backwards now. We can all turn it around. We're going to drive the regular way. How are we supposed to be driving? And a proceeding will be initiated. And that process will begin. And the United States, the International Court of Justice has already set a precedence of issuing that same type of order regarding this peremptory type of norm. So the precedence is there. But we could not get to that stage unless it was clear that the acting government had the capacity to, in fact, represent the Hawaiian state in the proceedings that we will, in due time, initiate.
Well, I tell you, Dr. Sai, I'm really looking forward to getting in that Porsche and with you driving. This is going to be very, very exciting. And I hope for those of you here that have been watching our show, will learn from this and stay tuned for more of Kanaka Express shows, because we'll be bringing more of this information to you. And I'd like to thank my guest tonight, Dr. Keanu Sai, for joining me. And Dave, mahalo for another great show. And Doreen, ke aloha nui, mahalo for a great production. So until we see you the next time, ahui ho everybody, aloha.